Resurgent India Limited is a SEBI-registered Category 1 merchant bank established in 2005. We help financial institutions identify the right business entities and work with businesses to secure the right amount of capital at the right time, fostering stronger enterprises and a more resilient economy and society. With over 300 professionals and a nationwide presence, we are market leaders in debt syndication and stressed asset advisory. Resurgent offers a 360-degree service model, supporting businesses across their entire financial life cycle, from project appraisal, valuations, and regulatory compliance to capital raising for early and growth stage companies, and further, to stress resolution and insolvency advisory. We are with you at every critical stage. Tailored solutions to meet your needs. Resurgent India Knowledge Series in collaboration with Resurgent Legal LLP presents initiation of CIRP and liquidation of the corporate persons under IBC. Moderator Ms. Tanya Anand, Resurgent Resolution Professionals LLP. Eminent speakers: Mr. Azim Tariq Khan, Insolvency Professional, Corporate Law and Litigations Consultant. Mr. Ashish Narayan, Insolvency Professional and Company Secretary, Management Consultant.
Good afternoon, everyone. On behalf of Resurgent India and Resurgent Legal LLP, I warmly welcome you all to today's webinar under the Resurgent India Knowledge Series. Thank you for taking the time to join us in this session on initiation of CIRP and liquidation of corporate persons under the Insolvency and Bankruptcy Code. I am Tanya Anand, Senior Manager at Resurgent Resolution Professionals LLP, and I will be moderating today's session. We are privileged to have with us two eminent professionals who bring extensive experience and practical insight into insolvency and corporate restructuring. It is my pleasure to introduce our first speaker, Mr. Ashish Narayan, sir. Mr. Narayan is a fellow member of the Institute of Company Secretaries of India, a practicing company secretary, and an insolvency professional. He also holds qualifications in law and management and has over 25 years of experience in the field of corporate affairs, resolution of stressed assets, management consultancy. He is actively involved in handling assignments under the Insolvency and Bankruptcy Code. It is now my pleasure to introduce our second speaker, Mr. Azim Tariq Khan. Mr. Khan is a fellow member of the Institute of Company Secretaries of India, a CMA, a CGMA, and insolvency professional, and holds qualification in law and management. He has over 15 years of experience in corporate affairs, legal consulting, and corporate restructuring, and has been actively advising on insolvency and restructuring matters. So before we formally begin today's webinar, I would like to take a few minutes to briefly set the context around why the Insolvency and Bankruptcy Code was introduced in India and how it has transformed the insolvency landscape. So prior to the enactment of the Insolvency and Bankruptcy Code in 2016, India's framework for dealing with stressed and defaulting entities was highly fragmented and inefficient. Multiple laws governed different aspects of insolvency and recovery, such as the Sikh Industrial Companies Act, the Recovery of Debts Due to Banks and Financial Institutions Act, provisions under the Companies Act. These laws operated in silos, leading to overlapping jurisdictions, prolonged litigation, and significant delays. As a result, resolution of stressed assets often took several years. Value erosion of business was very common. Lenders faced low recoveries, and there was no certainty or predictability in outcomes. Most importantly, the system was largely debtor-driven with limited incentives for timely resolution. So recognizing these shortcomings, there arose a strong need for comprehensive, time-bound, and creditor-centric insolvency framework, one that could balance the interests of all stakeholders while preserving the value of viable businesses. This led to the introduction of Insolvency and Bankruptcy Code in 2016, which consolidated the existing insolvency laws into a single unified framework. The IBC marked a paradigm shift by introducing a time-bound corporate insolvency resolution process, placing decision-making power in the hands of the creditors and prioritizing resolution over liquidation. So the primary objectives of IBC are to maximize the value of assets, promote entrepreneurship, improve availability of credit, and ensure time-bound resolution of insolvency. The code also aims to strike a balance between interests of creditors, debtors, employees, and other stakeholders while strengthening overall credit discipline in the economy. Since its implementation, the IBC has significantly altered borrower behavior by instilling financial discipline and accountability. Even in cases where insolvency proceedings do not culminate in resolution, the mere initiation of CIRP has often acted as a catalyst for settlements and restructuring. The code has also enabled meaningful recoveries for lenders through both resolution and liquidation processes, while ensuring transparency and fairness in the process. More importantly, the IBC has shifted the focus from recovery alone to value preservation and revival of businesses wherever possible. While challenges and evolving jurisprudence remain, there is no doubt that the IBC has emerged as one of the most impactful economic reforms in India's recent history. With this background, today's webinar aims to take you through the practical and legal aspects of initiation of CIRP and liquidation, guided by experienced professionals who will share their insights and hands-on experience on the code. Through today's discussion, our objective is to provide clear and practical understanding of the applicability of IBC, initiation of CIRP, the CIRP process, and liquidation. So before we proceed further, I would like to request all the participants to post their questions in the chat box, and as and when they arise during this session. So based on the time availability, our speakers will be happy to address selected questions towards the end of the webinar during the question and answer session. So we will begin today's discussion with Mr. Narayan setting the foundation on the applicability and effectiveness of the IBC. Sir, Ashish sir, to set the foundation of our participants, could you please explain the applicability of Insolvency and Bankruptcy Code, particularly covering who qualifies as a corporate person, who qualifies as a corporate debtor, and the role of corporate and personal guarantors under the code?
Right. Thank you. So see, IBC, first of all, why IBC is called a code? First of all, we should understand what is code, why it is called code. It is a confluence of many other acts. So as far as applicability is concerned, Section 2 of the IBC deals with applicability, and Section 2 is the foundational provision that determines the applicability and jurisdictional reach of the code. It operates as the statutory gateway that identifies the classes of persons and entities that can be subjected to insolvency resolution, liquidation, voluntary liquidation, or bankruptcy proceeding under the IBC. This provision makes it clear that the code is primarily designed to deal with the insolvency of corporate entities and only in a limited and separately structured manner with individuals and partnership firm under Part 3. Therefore, before invoking any substantive provision such as Section 7, 9, or 10, where applications are made for admission, the first legal test is whether the entity concerned falls within the ambit of Section 2. Section 2, subsection A brings within its scope any company incorporated under the Companies Act 2013 or any previous company law. Previous company law means there were Companies Act 1956 already in existence before Companies Act 2013. The legislative intent is to subject all companies, whether private, public, listed, or unlisted, to a common insolvency framework, thereby eliminating fragmented recovery mechanisms that earlier existed under multiple statutes. Once a company satisfies this criterion, it becomes amenable to corporate insolvency resolution process, CIRP, liquidation and voluntary liquidation under the code. And this means that it has to be incorporated under the statutory framework, which deals with section 2A. It has to be registered unless it is registered with the Companies Act, either Companies Act 2013 or the prior act. Jurisdiction is not applicable. It has to be registered with the ROC. For an insolvency perspective, incorporation is the jurisdictional trigger. If an entity is not incorporated, NCLT has no jurisdiction under section 7, 9 or 10 of the IBC to admit a CIRP application against it. Conversely, once incorporation is established, issues relating to shareholding, management disputes or internal governance are irrelevant for determining applicability of the code. In substance, incorporated in section 2A signifies that IBC applies only to statutorily created corporate entities, not to business in general. Section 2B extends to the applicability of IBC to companies governed by special acts, but with an important qualification. Only to the extent that the provision of IBC are not inconsistent with the provision of such special acts. This reflects the principle of harmonious construction. For the sake of interpretation, we have to apply the harmonious construction of interpretation. For instance, sectors such as banking, insurance, electricity are governed by sector-specific regulatory statutes. Where a direct inconsistency exists, the special statute prevails. However, in the absence of inconsistency, the IBC can operate. This clause demonstrates that Parliament did not intend the IBC to automatically override all special laws, but rather to coexist with them unless a conflict arises. Subsection C of section 2 expressly includes limited liability partnership, LLP. Legislature places LLPs on the same footing as companies for insolvency purposes, recognizing that LLPs, despite their hybrid nature, are corporate persons with limited liability character. Consequently, LLPs can be subjected to CIRP and liquidation proceedings in the same manner as companies, reinforcing the court's objective of value maximization and creditor protection across corporate structures. And section 2D empowers the central government to notify any other body incorporated under any law for the time being in force to be covered under the IBC. This is a dynamic and enabling provision intended to give flexibility to the insolvency framework so that emerging corporate forms or specific classes of entities can be brought within the fold of code and as and when required. This provision has been used, for example, to create a tailored insolvency framework for certain financial service providers under section 227 of the code without disturbing the core architecture of section 2. Under section 227 of the code, we have already in place financial service providers regulations. So under section 219, in which the famous case of DHFL also we have seen. A crucial aspect of section 2 is what it does not include. Sole proprietorship, Hindu undivided families, traditional partnership firms and individuals do not fall within section 2 and are therefore outside the scope of corporate insolvency. Their insolvency and bankruptcy are governed separately under Part 3 of IBC. This structural separation underlines the court's design philosophy. Corporate insolvency is treated as a distinct economic phenomenon requiring speed, credit control, and institutional resolution, whereas individual insolvency follows a different policy logic. Section 2 must be read in conjunction with definition of corporate person under section 3, subsection 7. While section 2 undermines applicability, section 3(7) determines legal character. Together, these provisions ensure that only those entities that are both incorporated with limited liability and statutorily covered can be proceeded against under the corporate insolvency regime. Courts and tribunals have consistently held that once an entity falls within Section 2, the jurisdiction of AA under the IBC cannot be ousted by contractual arrangement or parallel recovery proceedings. In essence, Section 2 performs a gatekeeping function. It demarcates the boundary between corporate and non-corporate insolvency, balances the supremacy of the IBC with special statutes, and ensures certainty as to who can be dragged into insolvency process. The detailed and carefully structured scope of Section 2 reflects the legislative intent to create a predictable, uniform, and comprehensive insolvency regime for corporate persons in India. A new category, personal guarantor to the corporate debtor, were introduced, which has been constitutionally validated by the famous Supreme Court judgment in Lalit Kumar case. Hence, the rule and regulation made for insolvency resolution of the personal guarantor of the corporate debtor were recognized. This Lalit Kumar Jain case for the Supreme Court's in the matter of personal insolvency was the major judgment. All the personal guarantors like those Ambanis and Singles, and together with many other famous personal guarantors, have combined together and filed an application before the Supreme Court challenging the validity of this act. Just a moment. Just a minute. This is charging is going down. Just
Azim, sir.
yeah.
Yes.
So me.
Yeah.
All right. Ashish sir is back. We'll get to you in some time, sir.
Thank you.
And we have to understand the definition of corporate person, corporate debtor, corporate guarantor. Also, to understand the applicability of IBC, corporate person means a company as defined in clause 20 of Section 2 of Companies Act 2013, a limited liability partnership or any other person incorporated with limited liability under any law for the term in force, but shall not include any financial service provider. Section 220 of the Companies Act 2013 provides that company means a company incorporated under this act or under any previous company law. Hence, all companies incorporated under the Companies Act shall be considered as a corporate person. The definition emphasizes incorporation with limited liability as the core criterion. It includes companies and LLPs and may extend to other bodies corporate if they possess limited liability and statutory incorporation. Financial service providers are expressly excluded, recognizing their systemic importance and the need for a separate insolvency framework. The significance of this definition lies in the fact that only a corporate person can be subjected to a CIRP and liquidation under Part 2 of IBC. If an entity does not qualify as a corporate person, the NCLT lacks jurisdiction in entertaining insolvency proceedings against it. Corporate debtor is defined in Section 3(8) of the IBC. It is defined as means corporate debtor means a corporate person who owes a debt to any person. That means a corporate debtor is a corporate person in default. The moment a corporate person incurs a debt and commits a default, it acquires the legal character of a corporate debtor for the purpose of the code. The definition is deliberately broad and does not differentiate between type of debts, creditor, or cause of default. And corporate guarantee is defined under Section 55A, means a corporate person who is a surety in a contract or contract of a guarantee to a corporate debtor. That means a corporate guarantee is Guarantor is a corporate person that guarantees the debts of another corporate debtor. Personal guarantor is defined in section 522 of IBC, means an individual who is the surety in a contract of guarantee to a corporate debtor. That means an individual natural person who guarantees the debt of a corporate debtor. Unlike corporate guarantors, personal guarantors fall outside the scope of Part 2 of IBC and are governed by Part 3, which deals with insolvency and bankruptcy of individuals. Yes, Tanya, this was the applicability.
Right, sir. So thank you so much for that comprehensive explanation. Building on that understanding, participants often wish to know how effective IBC has been in practice. So could you please share your insights on the success of the IBC, considering you've been an insolvency professional for quite some time, in the resolution of stressed assets, particularly in terms of realization for lenders and other stakeholders under the CIRP liquidation and personal insolvency frameworks?
Yes, of course. The success of IBC in the resolution of stressed asset lies merely in recovery percentages, but not merely in the recovery percentages, but in the systemic transformation of India's credit and insolvency ecosystem. Prior to IBC, resolution of stressed asset was fragmented across multiple laws such as Companies Act, RDB, BIFR regime, resulting in inordinate delays, erosion of asset value, and weak creditor discipline. The IBC replaced the debtor in possession framework with a creditor in control, time-bound, and market-driven resolution mechanism, fundamentally altering the behavior of borrowers, lenders, and investors. One of the most significant achievements of IBC is the introduction of strict timeline-based CIRP. The code mandate completion of CIRP within 180 days, extendable up to maximum 330 days, including litigation. The value maximization objective embedded in the preamble of the IBC has been a key contributor to its success. The resolution under IBC is not recovery-centric, but enterprise-centric. The code focuses on keeping the corporate debtor as a going concern, thereby preserving jobs, supply chains, and productivity capacity. Successful resolution plans have often yielded recoveries substantially higher than liquidation value, and in many cases higher than what creditors could have achieved through individual enforcement actions. Importantly, resolution value is discovered through a competitive bidding process, ensuring market-determined outcomes rather than administrative discretion. Another critical measure of success is the improvement in the creditor discipline and credit culture. The mere threat of initiation of CRP has led to a large number of pre-admission settlements and repayments. IBC also delivered significant outcomes in terms of realization to lenders and stakeholders. Financial creditors, particularly banks, have been able to clean up balance sheets by resolving long-pending, non-performing assets. Operational creditors, though lower in priority, benefit from a transparent claim process and statutory protection against discriminatory treatment in resolution plans. The court success extends beyond CRP to group structures and guarantee enforcement by allowing simultaneous or independent proceedings against corporate guarantors and personal guarantors. The IBC has strengthened recovery prospects in complex financing arrangements. From an institutional perspective, the establishment of specialized adjudicatory forums like NCLT or NCLAT, and a professional ecosystem of IPs, information utilities, IUs, and registered valuers has brought predictability, expertise, and transparency to the resolution process. In sum, the success of the IBC in resolving a stressed asset is reflected in timely resolutions, improved recovery outcomes, behavioral correction among borrowers, revival of viable businesses, and systemic financial stability. While challenges such as delays due to litigation and sector-specific complexities remain, the IBC has unequivocally shifted India from a debtor-friendly recovery regime to a creditor-led resolution-focused insolvency framework, marking a structural reform rather than a mere legislative change. If you see the status of CRP cases under IBC, so far resolved 14%, liquidated 44% of the total case, ongoing is 41%. While liquidation appears higher in absolute terms, largely legacy NPAs admitted in early years, the trend has reversed in recent years, with resolution increasingly outpacing liquidations. Average recovery rate, IBC versus pre-IBC, if we compare, IBC regime 32.7% is the average recovery rate. Pre-IBC regime, it was only 23%. IBC delivers substantially superior recovery compared to earlier mechanisms like BFR, SURFACE, DRT, and RDB, primarily due to time-bound process, IBC being time-bound process, competitive bidding, creditor in control model. Resolution versus liquidation trend, if we see initial years, it was one resolution for every liquidation. Now it is recent years, two resolution for every liquidation. Yes, Tanya, back to you.
Well, thank you so much, sir, for those valuable insights. So, having understood the applicability of IBC and its impact in resolving the stressed assets, we now move to the legal mechanics of how the insolvency resolution process is actually initiated under the code. So, Azim sir, I would now like to understand from you the legal framework and practical considerations involved in triggering the CIRP, particularly under the relevant provisions of the IBC. Could you please explain the initiation of CIRP under the IBC with particular emphasis on legal aspects involved in invoking sections 7, 9, 10, and other relevant sections like section 14 of the code?
Thank you for this opportunity. Actually, I heard Mr. Ashish Narayan, and he explained very well about the applicability of the IBC and the present statistics published by the IBBI. So after such draconian act, which are the recovery centric, the Parliament had introduced the IBC for a resolution of corporate debtor. It means companies to put forth a hand in the economies, which is only based for the ease of doing the business, to make the place India for ease of doing of business. So before starting the provisions, I would like to explain the terminologies involved in the CIRP process and liquidation process, which is much keen to be understood before filing any application. So I would like to use the code, regulation, and rules together in this screen. So I am sharing it is and explain each and everything. And Ashish ji is also requested they may discuss with me. And Tanya, you are also from the Research and Resolution Professional LLP and also doing the great job in various CIRP and liquidation cases. So if we can make it a more interactive session to enable our attendees and participants to raise their genuine and valid legal question. So we try to address them. So I am sharing it. Is it visible, Tanya?
Yes, sir.
Yes, sir. So first of all, as Ashish Narayan ji explained, the definition of the corporate person, corporate debtor, and corporate guarantor and personal guarantor. So the IBC is applicable. There are the two parts majorly. One part is the corporate insolvency resolution process and liquidation process. That is the one part which is centric to the corporate person and related to the corporate debtor resolution and liquidation. And other part is the personal insolvency and bankruptcy matters. So presently, the main motive of this webinar to relate only to the corporate debtor. So first of all, we have to understand the definition of the claim, which is from where the genesis of debt arises. Because in IBC, any application for insolvency resolution process could be initiated only as and when the debt is proved and there must be a default. So how a debt could be proved? So let's understand the section 3 subsection 6 of IBC code provides a definition of claim. It means The word is means. It means if the legislature express the terminology means, it means the definition is restrictive to the provisions whatsoever mentioned in that particular section. So the claims means a right to payment, whether or not such right reduced to the judgment, fixed, disputed, undisputed, legal, equitable, secured, or unsecured. So this says if any party, if any person have right to payment under any contract, whether it is reduced under a judgment, whether it is decreed, even it is a disputed, it must be a claim if there is any essence of right to payment. In the same sense, the second provision, second clause, the right to remedy arising from the breach of the contract. Suppose if any contract is breached, it ultimately results a claim. So as and when the right to payment is arise, it would be considered as a claim. And now come to how a claim converted into a debt. So when we come to the subsection 11, which defines the debt, that means the liability or obligation in respect of a claim. It means there must be a claim, and liability in respect of a claim become a debt, and it includes the financial debt and operational debt. The terminology used, the words used, the financial debt and operational debt, introduced in the IBC because of the bifurcation of the two set of creditors. One set of creditors are the financial creditors, which are mostly the financial institution. IBC specifically defined what are the financial debt and what would be considered as a financial creditor, and operational creditor relating to the goods and services. So now come to the special term, which is default, which is mostly understood by the various advocates and insolvency professional during implementing this definition. The default means the non-payment of debt. It means, first thing, there must be a claim. If there is any liability or obligation for any claim, it become a debt. And if there is any non-payment of debt, whether is whole or in part, it become a default. So if that is proved, default is proved, then a creditor become eligible to file an application against any corporate debtor for initiation of CIRP. So section 4 of the IBC is specifically given a threshold. Earlier it was a rupees 1 lakh rupees, and presently it is the 1 crore rupees. If there is a default by a corporate debtor against any financial creditor or operational creditor for rupees 1 crore or more, then a creditor become eligible to file an application. So now come forward for the next definitions. So and this definition, the person is very important to understand, because in the IBC context, the person, there are many terminology used as the any person. So the IBC specifically defined who shall be the person for the IBC. IBC includes an individual, Hindu family, a company, trust, partnership firm, limited liability partnership, and any other entity established under a statute. So if we talk about in the context of the creditor, so a person who can be the creditor. It may be a company and trust and partnership firm, limited liability, and other entity established under a statute. But here the major chunk is the word used, the include. I have already highlighted, because when you go to the Baiju, it means the BCCI cases. So BCCI was a society. So the honorable courts interpreted that the definition of person includes. It means it is inclusive. If there is a context and connection, then any person who is a creditor can initiate the CIRP against any corporate debtor. So, and their terms, the prescribed use in the statute to define that any rules as and where the word prescribed used in the IBC, it means that it should be linked to the adjudicating authority rules, which are framed by the central government for initiation of CIRP. So these are the things. Now come to the definition of the corporate applicant, because there are three types of initiation. First is under section 7, a financial creditor can initiate a CIRP against a corporate debtor. Section 9, an operational creditor initiate a CIRP against corporate debtor. And section 10, which says a corporate debtor itself initiate its own corporate insolvency resolution process if there is a default. But the terminology is used who will be the applicant. So there is specific terms used, the corporate applicant. So corporate applicant, it means a corporate debtor its own, or any member or partner who is under the constitutional document. They are eligible to initiate the section 10 application on behalf of the corporate debtor, being a corporate applicant. And an individual, the term used is the an individual. Suppose there is any managing director who is looking all the operation and resources of the corporate debtor is eligible to act as a corporate applicant, and any person who controls and supervision over the financial affairs. So there is the two terms in subclause C, the word use an individual. Suppose if any person who is the member partner under the constitutional document and any managing person who involved in the affairs of the company are eligible as a corporate applicant, and a person who has control and supervision over the financial affair. The term used, the person, reveals that suppose if any corporate debtor have any other company as a member, like any holding company or any associate company who has the control and supervision on the financial affair of the corporate debtor, then that person also act as a corporate applicant and file section 10 application for that corporate debtor for any default. So the terms the corporate guarantor is already well defined by Mr. Ashish Ji, so I'm not going into it. So now come to the definition of the financial debt. The financial debt means the debt along with interest. So here, there and if any, which is disbursed against the time consideration of time value of money. So this is very important definition. The parent clause of this definition is means debt. For qualifying a financial debt, there must be a debt. We understood that how a debt become a debt. So along with interest, if any. So it is not necessary that any financial debt to be qualified, there should be an essence of interest. Without interest, it could be a financial debt. But the trigger point for qualifying a financial debt is that it must be disbursed against the time value of money. It means whatsoever is lent or given, it must have effect of any benefit that is converted in form of monetary terms or any other benefits to the creditor from the corporate debtor. So the parent situation is this: if there is essence of the time value of money, in number of cases in the pioneer urban case and various cases, Honorable Supreme Court clarified that if there is no disbursal of consideration for time value of money, then such debt cannot be qualified as a financial debt. And after the development in IBC regime, there are the home buyer cases matter. So the definition also includes if any amount raised from an LOT under a real estate project shall be deemed to be an amount of the commercial effect of borrowing. So it means if in any matter for initiation of CIRP, if LOTs or home buyers who has deposited their amount and that real estate project raised money for that real estate project from the LOT's money, then these LOTs considered as a financial creditor and their debt shall be considered as a financial debt. So the creditor who owed a financial debt shall be considered as a financial creditor. And in terms of operational creditor, so operational creditor are not linked with the funding or any economic affairs of the company. They are directly related to the provisions of the goods and services. So the operational debt means a claim in respect of provision of goods and services. So here it is notable that if there is any debt or any claim relating to the goods and services supplied by the corporate debtor or supplied to the corporate debtor, because the Honorable Supreme Court also clarified that this is the open-ended definition. Okay, so it cannot be limited to a creditor-debtor relationship. If there is a provision of goods and services, then any person who owed the debt become the creditor and other person become a debtor. if they qualifies the definition of the corporate debtor, then other party can initiate the CIRP based subject to the threshold limit. So these are the things to be taken in mind before going to the Section 7 application. Section related to the initiation of CIRP by the financial creditor. So Tanya, do you have any comment or questions, or Ashish ji may discuss here? Because I think I am too fast. I am feeling.
Yeah.
So if there is anything to discuss, then we can deliberate here for benefit of
I
all
have a
parties.
question on corporate applicant, which you have just now said little while ago. So
Yeah.
corporate applicant, whether holding company of a corporate debtor can be an applicant.
Yes, 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 sir. So look the definition. Suppose a person who has control. So
Control or supervision. Yeah, that's
control and supervision. So the holding company holds the more than 50%. So they have the ultimate control on the financial affairs, and they can be a corporate person. They can be individual.
okay.
Suppose
If any group company, then if that company holds more than 51%, then can be a corporate applicant.
yes, in case of the holding subsidiary scenario, but when we look the term, the word is use the control. So if it is proved that there is a substantial control over the affairs of the corporate debtor, then they can act as a corporate applicant for initiation. For example, suppose if any associate company having more than 20% shareholding, so they have right to elect their director. They have they can influence the decision making. So they have an active control over the corporate debtor. So they should be considered as a person, and they may file an application for that company for which they have a controlling right. So yes, sir. So we move forward to come to Section 7. The Section 7 talks about the initiation of the corporate insolvency resolution process. One second. Is it visible to all?
Yes, sir.
Give me 1 second. So we understood about the financial creditors, and now Section 7 application. I am just opening the code. Actually, it's down. 1 second. Tanya, is it IBC code is visible to you?
It's visible.
Tanya?
It's visible. I
Yes,
think.
yes. It's visible. However, there are certain glitches on the screen.
Yeah, some blackish is coming up and down.
There are certain glitches on the screen, sir. I think you should unshare it and then share it again.
Now it is visible clearly?
Yes,
Okay.
yes, clear.
So Section 7 is specifically said that a financial creditor, either itself or jointly with other financial creditor. So this is the first condition. Financial creditor alone or jointly with other financial creditor can file a Section 7 application. First thing. Second, any other person on behalf of the financial creditor as may be notified by the central government. So, as Mr. Narayan he explained about the DHFL case. So, and if we go to the definition of the corporate data and corporate persons, so they exclusively excludes the financial service industries. So these phrase used in this section 7 gives the power to the RBI to file an application for the financial sector companies. So these are specifically separated. And one more thing for the threshold, if the word used is the jointly. So the if for example, one financial creditor has the 40 crores debt and default again, and another have 60 crore 60 lakh rupees. So they can jointly make the threshold of rupees 1 crore rupees. So that could also be possible. And in the real estate project, if the LOTs jointly can file the Section 7 application, there must be a threshold of 100, or for meeting a threshold of 1 crore rupees, at least 10% of total debt LOTs can file an application under Section 7 against the corporate data. And now come to the main point, how Section 7 application shall be filed. A financial creditor shall make an application under subsection 1 in specified form and accompanied by a fee as may be prescribed. So the terms used as the prescribed, it means we have to go into the rules. So the rules are here. It means the application by the financial creditor. So in a financial creditor must either jointly or individually file an application under Section 7 in form F1 and along with the documents mentioned in the CIRP regulations. So we have to go into the CIRP regulations. What the CIRP regulation says? CIRP regulation says that a financial creditor can prove their existence of debt by, if the record is available in the information utility. Second, there must be a financial contract. So first, what is the financial contract? Financial contract means an agreement between the corporate debtor and creditor for a certain amount of sum that has been lent and reduced in a form of an agreement constituting the terms and condition of such financial facility. So that could be considered as a financial contract. And any record of like the financial statement or bank statement that reveals that the debt has not been paid and remain unpaid. So these are documents to be provided by the financial creditor in the Section 7 application. And as and when the application is filed, the NCLT has jurisdiction to ascertain the debt and default. And how adjudicating authority, because there are the number of cases which says that the adjudicating authority cannot entertain the third party, because before admission of any CIRP application, the application is in personam, and after admission of the CIRP application, it becomes an in rem. So in personam means that application, whatsoever petition filed for the initiation, is between the creditor and corporate debtor. In that case, the adjudicating authority must ascertain whether there is a debt and there must be a default. If the both conditions satisfied, then adjudicating authority must admit the application. And there is a
Sir, I'm so sorry to interrupt here, but I think this is the right time to ask one of the questions by our participant. So here the participant is asking whether a foreign creditor can invoke IBC without RBI compliance. What about foreign creditors here?
there is no distinguishment of the Indian creditor or foreign creditor. For a foreign creditor, if they are falling under the category of the financial creditor and operational creditor, then they can invoke the IBC. There is no issue, because the IBC does not bar any jurisdiction or territorial limitation for filing any CIRP regulation. Only the limitation is related to the foreign decrees and foreign arbitral award. For example, if any debt arising from the foreign award or foreign decree, then there is a another institute like the Civil Procedure Code, which said that until and unless it is executable and enforceable in India, it cannot be considered as a decree in India. So, for example, if any creditor have a foreign decree and they want to pursue the CIRP application in India, then they have to go to the Honorable High Court of that jurisdiction in which the registered office of the company is situated, and then they file under section 36 of arbitration application, in which the Honorable Tribunal declare is a decree and enforcement direction, execution decree. In that case, they become the creditor under the IBC for filing CIRP application. But the matter relating to filing the claim in the ongoing CIRP is a different. So that is not the topic today. So we can discuss in the later webinar. But yes, any foreign creditor who has the legitimate dues and default, if he prove, then he can file any Section 7 or Section 9 application in India against Indian corporate debtor. So
All right, sir. Thank you.
So this is the scenario. And the word, when we come to the subsection 5, it clearly says where the adjudicating authority is satisfied that a default has occurred, and the application under subsection 2 is complete, and there is no disciplinary proceeding pending against the proposed insolvency resolution professional. So one more thing I would like to add, like there are the 3 sections for initiation of CIRP. So it is mandatory for the Section 7 application and Section 10 application that any financial creditor or corporate applicant filing any application for CIRP must disclose and nominate the insolvency professional to act as an interim resolution professional. However, in the context of the Section 9, which is related to the initiation of CIRP by the operational creditor, there is a discretionary this discretion to the operational creditor. They may or may not propose the name of the insolvency resolution professional. So this is the case, and the word used when it is complete, default is proved and application is complete, then the adjudicating authority may by order admit the application. So it is very relevant to understand the recent earlier case which is now highlighted, that is the Vidarbha case, in which case the Honorable High Court given rejected the Section 7 application based on the certain facts, but in the later judgments the Honorable Supreme Court clarified that the adjudicating authority only the debt and default. There is no scenario whether there is any lacuna, there is any lapses, and no third party could be introduced before admission of the application. So now the terms used is may, shall be read as a shall, and it is the fact to fact basis. So if there is no default and if there is any incompleteness in the application, then the adjudicating authority may reject the application by way of order. So this is the Section 7 application. And now come to the next phase of insolvency, where the operational creditors, which are much deprived earlier in earlier regimes, where they have no option to get their legitimate money for which they have provided services or supplied goods to the corporate debtor. So the now IBC brought a statutory framework through Section 8 and Section 9 for initiation of CIRP against the corporate debtor. So before filing Section 9 application, which is from the operational creditor, there is mandatory requirement of serving a demand notice. So the terms used is that deliver a demand notice. It means if any operational creditor willing to file any Section 9 application, they must deliver a demand notice of unpaid operational debt to the corporate debtor. And corporate debtor is required, it is the specific time, as and when the notice received by the corporate debtor, they has to reply within 10 days. And they may brought to the notice of the creditor existence of dispute, or it means if there is any pre-existing dispute relating to the goods and services. And it must be understood here, if corporate debtor raising any dispute, it must be related to the debt for which the demand notice has been sent. For example, the debt is related to supply of ingot or any iron rods. So the corporate debtor cannot raise any dispute relating to the other supplies or other matter for which the invoices are not raised. Or invoices raised are not, invoices may be raised, but that is not concerned to the debt in dispute, debt in the for auditors. So that has to be understood. If there is any pending suit or any arbitration proceeding before receipt of the demand notice, suppose the demand notice is received on 23rd January 2026, then the dispute can be raised for those suits and arbitration proceedings that are initiated or pending as on 23rd. Any suit or arbitration invoked after 23rd January 2026 cannot be considered as a dispute. So these are the conditions. If the corporate debtor had paid the amount, then they may prove the same to the operational creditor. Suppose if the corporate debtor,
Yeah,
yes,
Ajit, I have a relevant question related
yes,
to
sir,
operational creditor
yes, sir,
filing an application under Section 9. If
yes,
operational
sir.
creditor intends to file an application under IBC, but before that, he has gone to arbitration and he is not satisfied with the decision of arbitrator, whether it
Okay.
will be regarded as a dispute before filing an application under IBC because he has
Yeah.
gone to arbitrator.
Yes,
And
yes, yes, sir.
so
Sir, there,
whether it's
that is,
pre-existing dispute and therefore it
yes,
will be rejected in IBC.
yes, sir. This is pre-existing dispute. As earlier I have clearly demarcated. There are two things. One thing is the initiation of CIRP, and second, you're claiming anything after initiation of CIRP. For invoking initiation of CIRP, if there is any dispute which includes any suit filed or any arbitration filed or any proceeding pending before the filing, before the serving the demand notice, it constitute as a dispute, because when the arbitration, if it is pending, it means the dispute is not resolved. If it is already resolved, arbitral award is passed, then the uh, parties to the arbitration has right to appeal under section 34. Section 34 gives the 3-month time for, this is the limitation period, 3-month time, and 30 days and additional period. It means if the 120 days lapsed and there is no appeal, then it is fructified, then it considered no dispute. But if that period is not expired, then the party, it means the judgment debtor, has right to appeal, because he has right under 34 and also under 37 to go before the honorable high court. And even after 37 is rejected, then he has right to go to the Supreme Court. So it is not the completely adjudicated uh, amount considered for the initiation, and it is considered as a dispute. So hope Ashish ji, I have clarified.
Yes, yes. Thank you.
Okay, sir. So and now when the demand notice, if there is any if the reply is received by the creditor from the corporate debtor and they not satisfied the any debt due, so after the expiry of 10 days of delivery of the notice, the operational creditor has become eligible to file an application under section 9 for initiation of CIRP. So these are the things, and these are the same for filing an application for the demand notice, they must serve the demand notice in form 4 of the adjudicating authority rules. And for proving the debt and default, there must be an enclosure of relevant document like the tax invoices and GSTR returns, which establish that the goods has been supplied or services has been rendered, and along with any contract or any financial statement, even the account statement that confirms that the amount has not been paid. So in the same line of section 7, the adjudicating authority ascertain the debt and default, and if we find that there is no pre-existing uh, dispute, so they must admit the application. So now the operational creditor portion is also completed. Now come to the section 10 application. As we discussed the corporate applicant, so now the corporate debtor, if the corporate debtor committed a default, then a corporate applicant thereof may file an application for initiation of corporate insolvency resolution process. But there is a requirement of having a special resolution approved by the shareholders or the members of the LLP, authorizing the filing of the corporate insolvency resolution process. And in the likewise section 7 application, the corporate applicant must disclose the name of the interim resolution professional to be appointed by the honorable adjudicating authority. So I think I have finished all three important sections here. Tanya and Ashish ji, do you have any other comment or any observation relating to these descriptions whatsoever I have tried to explain? Because IBC is very vast and it cannot be completed within a 1 hour for any section. There are a number of judgments based on the facts and circumstances of each case. So there are number of scenarios can be drawn. So Tanya, do you have any question? Or
Correct,
Ashish
sir.
ji?
And Sir, I think you have very thoroughly explained everything, and there is much that can be said in the matter. But however, considering the time restraints, we'll
Okay.
have to cut it short at the moment. And you have given quite a detailed explanation for the legal framework for initiation of CIRP. So, right now, however, since the primary objective of IBC is resolution, that is understood. But then there are cases where resolution is not feasible and liquidation becomes inevitable. So, to understand this aspect, I would like you to explain the liquidation framework. Could you
Okay.
please brief us about the initiation of liquidation process of the Insolvency and Bankruptcy Code, and most important provisions can be highlighted here, including the role of the liquidator, asset memorandum, sale of assets, etc.
Okay, so Ashish ji is also here. So I have a good experience with Ashish ji and dealing in some certain cases of the liquidation where the resolution not happened and a corporate debtor came under the liquidation process. So suppose if we go through the CIRP, when the CIRP application is admitted, then the RP become as in a driver's seat, and directors, board of directors are suspended, and they run the company as a going concern and invite the expression of interest from the public for participation in the resolution process. So, but the section 33 is relevant here. Suppose if any resolution plan received, but it is not approved by the adjudicating authority, suppose the adjudicating authority rejected this or the COC rejected it, then the ultimately there is no resolution possible. So that comes to the under section 33, and resolution professional shall file an application on behalf of the COC for liquidation of the corporate debtor. First thing, suppose the COC member who is the, because as you already explained, this is the creditor defense process. So suppose the COC member decided to liquidate the company corporate debtor, so they may by a special by a resolution supported by a 66% voting can approve the liquidation. But now the Supreme Court clarified that in any case, if the COC members thinking to liquidate the company, it must be supported by a genuine reasons, because it is ultimately after the liquidation the company dissolve and the existence of the corporate debtor, it means a company uh, become end. So this is the process, and this is the just in how it initiates. And like the CIRP, there is also a moratorium during the liquidation process. During the liquidation, the liquidator has to form a liquidation estate, and out of which he paid the all creditors. Like the CIRP, the liquidator invite the claims from the claimants and cause e-auction as per the liquidation regulation. And when the highest bidder come as per the schedule 1 of the liquidation regulation, and hand over the asset by following the process. There is much only two difference. RP during the CIRP is not an adjudicatory power. He is only the facilitator. But as and when the company comes into the liquidation, the liquidator has certain power and work under the supervision of the adjudicating authority. So I think I have concluded in short. So we can, I think there is time is also short. So Tanya, you may put the questions from the audience, and if you
Yes,
have any
yes.
question or from your team, so you may also place here. So the Ashish ji and I will try to address these questions.
Correct. Yes, so thank you very much, sir. I'd like to sincerely thank both our speakers, Mr. Ashish Narayan and Mr. Azim Tariq Khan, for sharing such insightful, practical, and experience-driven perspectives on the insolvency and bankruptcy code. So we'll be moving on to the question and answer session. We have received quite a few questions. However, I don't think due to time constraint we'll be able to answer all, but we'll try to answer as much as possible. So, sir, the first question that has been posted here is what qualifies as a pre-existing dispute and whether arbitration notice itself is a sufficient dispute here.
Yes, arbitration notice itself is a pre-existing dispute because if any notice is issued under the Arbitration Act, it is based on the arbitration clause. Because for invoking any arbitration, there must be a arbitration clause in the parent agreement, or there may be a separate arbitration agreement. So, if there is any issuance of the notice, then it shall be considered as a pre-existing dispute.
Correct. All right, sir. Sir, another question that we have here is whether workmen dues override secured creditors.
No. There is a misunderstanding of the judgment of the Rambo judgment. Rambo papers judgment
Yes,
was
correct.
given by the Honorable Supreme Court, wherein he expressly explained the first charge. As and when the government department, there are a number of the special institutes like the electricity institutes, like the GST, income tax, CGST, EPFO. So they have the certain provision in their own institute. So suppose any institute creating a first charge over the properties of the or assets of the corporate debtor, so then it shall be considered as a secured creditor. I am saying that a secured creditor, but by nature, whether the debt is operational, if the debt is operational, it become an operational secured creditor. So in that case, the Gujarat VAT was declared as a secured operational creditor. And in many cases, if suppose the income tax department, income tax act, there is no specific provision which deals about the first charge. In the same sense, we go to the Noida authority. So if we go to the in those institutes and those bylaws, so they specifically says that the any charge and outstanding of the Noida authority shall be the first charge over the property. So in the Prabhjit Singh case, Greater Noida versus Prabhjit Singh case, the
Yes,
Honorable Supreme Court also held that they are the secured creditors.
correct, sir. So, moving on to the next question, whether related party creditors can trigger CIRP.
Yes, they can trigger the CIRP. There is no issue because the definition of the financial creditors has not debar any related party. Related party relation context only relevant for the formation of the committee of creditors, because the section 21 says that the committee of creditors shall be formed by the financial creditor and they must not be a related party. But the relation of the related party shall be seen on the day of formation. Okay, so related party can initiate CIRP, but they cannot part of COC.
Yes, correct, correct. So moving on to the next question, whether home buyers are financial creditors in all cases. Just a little more detailed explanation on the status of the home buyers as financial creditors.
Yes, the allotee, as I have explained, the section 5 subsection 7 definition, which says the any allottees or under any real estate. If real estate project raised money from the allottees, then these allottees become the financial creditor in class. When we go to the CIRP regulation, it specifically defines the creditors in class. Creditor in class means if 10 or more creditors of a particular class shall be considered as a class of creditors. So yes, allottees, home buyers are the financial creditors in class, and they are equivalent to the financial creditors.
All right. Sir, moving ahead to our next question, which is again developer-driven question. So, to what extent has the initiation of insolvency and bankruptcy proceedings by the developer, sorry, against the developer, I think this is, affected the enforceability of penalty clauses and refund commitments of home buyers in respect of delayed or incomplete project?
Look, as and when the CIRP is initiated, I have already explained that this is the process and ramp. So whatsoever any person have any claim, they have to file before the IRP or RP, and the treatment of their claim shall be governed by the under the resolution plan proposed by the resolution applicant. There are only the two conditions. One is it must be comprised under section 30 subsection 2, which says that the liquidation value to be paid to the operational creditor and dissenting financial creditor. And second thing is that is given in the mandatory content under regulation 38 of the CIRP regulation. If it is complied, then the proposal must be passed a muster only after the commercial wisdom of the COC. If COC think fit, then they cannot go beyond the law. If that is compliant, then the distribution to the all claimant shall be paid under the resolution plan. Am I clarified clearly?
Yes, correct.
I have not understood clearly what the question was.
You've covered the topic. Basically, it meant how can home buyers recover the amount that they've lost, and I think you've covered that properly. So again, another real estate question by one of our participants. So we all know that many times, the CIRP is initiated under Section 10 with malified intentions. So what if a developer has filed for insolvency with the intent uh, for avoiding penalty exposure and refund payments to home buyers in relation to an incomplete project? So what happens then?
In that case, actually, there is no separate mechanism under the IPC to trace whether the CIRP was initiated for the malicious intent or not. If there is, because there is the two key definition to be understood. First is the initiation date, and that is, and second is the CIRP commencement date. Initiation date, it means the date on which the application was filed. That is the initiation date. But since the from initiation to commencement date, at that time the proceeding is in personam. It means it is between the creditor and debtor. In that case, if the application is admitted, and if home buyers thinks that the application has been filed for malicious intent to escape from the liability, then they may file a section 65 application, which says if there is any application initiation of CIRP or liquidation or pre-pack insolvency initiations for the malicious intent or to defraud the creditors, then there are the punishment and certain liabilities to be imposed on the parties who deliberately try to bring the corporate debtor under the IBC regime. So this is all.
Right, sir. And also, yes, sir. And also, it's not like the directors of the corporate debtor are free from scrutiny. We also have the preferential undervalued transaction audit.
Yes.
Conducted.
Yes, actually, IBC introduced like 43 to 51 section deals with the PUFE application, and another section is the section 66, which is related to the fraudulent transaction. And RP, the resolution professional, is duty bound to form their opinion and determine whether there is any the preferential or undervalued or the fraudulent transaction entered by the corporate debtor during the look back period. So they must identify and report before the honorable adjudicating authority for appropriate action, and the appropriate action may be punishment, maybe a reversal of these assets and recovery of these assets. And so that is the vast area. So because does not end to the at the CIRP stage, initiation stage. If the RP find the faults, then they may approach to the honorable NCLT.
Yes, correct. So moving ahead to our last question, considering that we don't have much time left and there are a lot of questions here, but we'll just cut it short right now. So the last question that I'll put up before you is with relation to arbitration proceedings. So can pending dispute or arbitration proceedings affect the admission of claims by the IRP? And what effect does arbitration in general have? when the CIRP process is ongoing?
If there is any pending arbitration award or arbitration award, it is a pre-existing dispute. It means based on the arbitral award, you can not invoke the Section 9 application. This is the first scenario I have explained. Now come to the claim part. Claim is only a claim. It is already explained in the claim definition. If it is a disputed or undisputed, whether it is executed or unexecuted, whether it is reduced under judgment or not, there must be a right to payment. If the arbitration award is given and there is a right to payment to the creditor, award holder, then they can file their claim to the before the resolution professional, and the nature of the debt defined whether it is operational or financial creditor. Suppose if the arbitral award is based for the on the operational debt, then they become the operational creditor, and if they're financial angle, then they become the financial creditor.
All right, sir. So, I'd like to thank both our speakers for sharing their valuable insights and practical perspectives on the insolvency and bankruptcy code. And I'd also like to thank all the participants for their active participation and interest in today's session. We hope that the discussion has provided you with greater clarity on the initiation of CRP and liquidation process. On behalf of Resurgent India and Resurgent Legal LLP, thank you all once again for joining us today. Thank you, Azim sir. Thank you, Ashish Narayan sir.
Thank
Have
you.
a wonderful evening. Thank you.